and the respondents. And my lord, the old principle applies that a judge, one cannot be a judge of his own cause, and in any matter that they are dealing with, it should be a matter that they are absolutely neutral as far as the facts and the evidence are concerned. My lord, in our African societies, I've talked to my parents, I talked to Mr. Ogata, he said his community had the same set of issues. According to my community that I came from, in any those cases that used to be done traditionally, the first thing that would arise was this, and Article 159 says we respect our customs. It was to ask those who will be able to determine this case, are all the parties satisfied with this group of wazes that will be deciding the case? If either of the parties
my community does not do that.
I don't know about yours. I say mine and Okada. Mine is
Okada is mine.
I don't know. Okada will talk for himself. But let me have some peace. I think he wants to destroy my train of thought. So at the point I was saying, I can be happy. Okada can defend himself what he told me. But my lord, I'm saying at least for my community, that issue would arise. Does any of you have a problem with any of these wazes who will decide the issue? My lord, if the issue arose that a party says, we don't want that wazee to be there or that other one, invariably, and this is communal justice, that person would pull out and get another mzee that everybody feels comfortable with. So that, my lord, and I've appeared with you, I respect all of you absolutely. The petitioners are saying the circumstances of this matter is that we are unable to enjoy that confidence. But when the petitioners were speaking about what they said they feel, like is a three-judge bench, one in which they expect fair and square justice. That was a terminology in the case of Gerongori that we have attached on our submissions. That from the word go, a party appearing before the judges should be able to feel that we have a reasonable chances of success between those judges, but more importantly, that none of the judges is connected to the cause, one, to the cause, or to the individual in which you are in dispute with. My lord, why is that important? That, my lord, is important because since Saturday of this week, in fact up to yesterday, the petitioner says they have been treated to a situation, and a lot of those information people have sent it to my phones because they have seen me on television. Where we have such a scenario that repeatedly they keep saying we are going to have what is it called? We are going to have a swearing in as soon as these three judges give to those particular orders. But that cannot create confidence, because assuming it is not this case, every party, and we have very many cases here, if somebody you are drinking in a bar says, no, you are going to lose that case before the persons we are appearing before, that, my lord, is a party. Parties are not lawyers, are not supposed to be sophisticated. That party will be left certainly with a huge problem as to whether actual justice is possible, and it might actually be, my lord, that whenever else is dealt, the petitioners will win this case. As we expect, we shall win if the petition is heard. But Lord, if that is the case, and that may actually be the case before you, but my lord, the scenario that is banned and that is prevented by the law is a scenario where the parties lose. Because they will say, well, you have Ahmed Nasir told us, Oscar Suki told us, Kariket told us, and all these individuals who are saying it was called drama. We are here for entertainment. But not if judges are supposed to be treated to entertainment, and those judges are supposed to stop that entertainment, but there is a problem on the face of it. There is a notice of appeal that we have filed, and it is part of a supplementary affidavit. In this notice of appeal, your lordships, we have pointed the issue, and we have said one of the other issues of concern is that the judgment of this court that dealt with these other issues, that judgment, the contents of that, amounted to preempting and answering the application that I'm arguing before the court. Because those issues we are submitting did not come from the respondents, but these applications having been filed, we are arguing these applications. After, in a previous ruling of yesterday, we have effectively been responded by the court itself. The petitioner says that they are absolutely uncomfortable